More. Let's bring in NBC News legal analyst Misty Marris. She joins us here on set. Misty, good morning. So let's just start. Walk us through the jury's decision in this case.
So what the plaintiffs argued was that this was essentially engineering addiction against YouTube and Meta. And what the jury found is that they were both liable for the way that these platforms were designed, addictive to minors, and that also there was a failure to warn about those dangers. Now, this was brought by a single plaintiff. We call her KGM because she was a minor at the time the harm occurred. And they found that actually her use of these platforms was the cause of mental health issues that she suffered, and ultimately awarded $3 million in compensatory damages and $3 million in punitive damages.
In the past, we've seen cases like this focus on content. This time it looked at sort of the design and delivery of that content and how it made things addictive. From a legal perspective, how did that change things?
So there's this law, federal law 230. We've talked about it a lot. And it actually precludes liability against social media companies for the content that third parties post on that platform. So the content is off limits. So these lawsuits are really circumventing that by bringing a product's liability theory. It's the same theory that we saw big tobacco. That's one of the comparisons. But any product, a defective toaster, you name it, it's the same legal theory. And it talks specifically about the algorithm, the design, the way that these platforms are made, and the fact that the companies in this case knew or should have known that it could be harmful to minors.
All right, so there is just a whole log of additional cases similar to this here. How could this verdict here impact those cases?
So this is a bellwether case, right? Meaning it's the first of its kind. Now it's made it through trial, and everybody was waiting to see how this case would turn out. So you got about 1,500 waiting in the wings, and now you see juries are finding liability. The eyes are on this case to see what's the jury going to do with this. What types of damages are we talking about? And keep in mind, if you're the defendants here, Meta and YouTube, and also all the other big tech social media platforms, you're watching this because you're looking at these issues globally. You're defending a lot of different cases, and you're strategizing not just based on this one case, but about how this, the legal landscape overall.
So we now have two cases this week, very different, making headlines. Both are jury cases. Does that suggest we're sort of seeing a sea change here in public opinion? And what could that mean for potentially many, many cases moving forward dealing with these issues?
Yes, we have a jury case in New Mexico brought by the state of New Mexico under a consumer frauds theory. This brought by a single plaintiff under a negligence theory. But to your point, 230, let me tell you when that law went into effect, 1996. So for those of us who remember the dial-up AOL internet, can't be on the phone while you're using it, well, now this is at your fingertips, every single app. So there's been a lot of momentum for change. The legislature has not been able, Congress has not been able to step in and make that change. And now you're seeing the change being made through this liability and litigation landscape.
Both companies here say that they plan to appeal. What does that end up looking like?
No surprise there, because even if this award were $1, we can all agree $6 million to these companies is not it's a drop in the bucket, right?
Totally.
But just because there's liability, if the award had been even less, they're going to appeal because the legal standard is developed in the appellate courts. The appellate court doesn't second guess, did a jury get it right? What they say is, should this have ever gone to the jury to begin with, taking into considerations all those protections that we spoke about?
Misty Marris, so interesting. Thank you so much.